a DAO operational side, and also including tax season. So what's next, Astra?
Thank you. Thank you from my side also for the Alexa and Johnny and everyone else. They went already quite deep into this legal challenge problem, right? So the next panel is all about legal stuff. So it's virtual asset regulations and MiCA. So why do we have this kind of name for this panel? It's not we're going to talk a lot about MiCA, because if you want to know specifically about that, there's actually a lot of events going around this topic. But we will focus more there on DAOs and how actually they are related to MiCA and virtual assets legalization. So please welcome the next panel here. Our moderator is Viljar Kähari. Today he's representing the Estonian language is like more easier, but Estonian Digital Assets Union, right? Board member. And offline, on stage, we're going to have with us Toomas Seppel, department from Hedman Law Firm. Also, please welcome Anna Agu, partner and founder from Lex Law. And online, I hope that in waiting room with us are two people. So first of all, Mari-Liis Kukk, the head of innovation department, Estonian Financial Supervision and Resolution Authority. Welcome, Mari-Liis. And Amardeep Thand is with us from Chainanalysis, and he's the regulation and compliance lead. Please enjoy the stage, and let's keep it going. Thank you.
Hello. So welcome to our next panel discussion. And today's main question is how market participants, financial supervision authorities, law firms, and also fintech and redtech companies can encourage innovation and also at the same time be compliant with all laws and regulations. So there are various types of DAOs available and operating, but we are currently focusing more on the DAOs which are on regulated business or might be in the regulated business. My name is Viljar Kähari. I'm here representing Estonian Digital Assets Union, and this union is representing companies who are providing digital asset services and products, and we help them to facilitate the dialogue with authorities, and also we help them to understand if they need a license for their operations, and also if needed, then we can assist them to get a license or refer to consultants who can help them. So let's continue with introductions. So Toomas, please.
Hello, nice to meet you all. I'm Toomas, Hedman Law Firm, Tallinn, Estonia, and we are working with Web3 companies and also with any kind of the new business which we see in the market, which is regulated, non-regulated, so all around this new tech, as we like that to say. And we also are founders of a couple of legal tech companies. So we are a consultant company as a law firm, and we also are building legal tech tools, but not yet anything around blockchain, maybe in the future, soon. So far, we are very old school. We're doing Web 2 only. Nice to meet you.
Hello, dear audience. My name is Anna Agu. I'm a co-founder and partner of Lex Law Office. We are a law firm based in Tallinn, Estonia, and Vilnius, Lithuania. And we work with fintech and IT clients all over the world. Thank you.
Mari-Liis.
Well, yes, good afternoon to everyone. I'm Mari-Liis. I'm the head of innovation department at Estonian FSA, and my department is also responsible for running our innovation hub. And it's important here that innovation department or the hub does not have any direct supervisory role, but instead we act as a facilitator, working on understanding innovative business models, their benefits and risks, and where they may fall under current regulations requiring a license.
Thank you. And Amardeep?
Hi, good afternoon, everybody. My name is Amardeep Thand, and I lead the regulation and compliance side for Chainanalysis. My main kind of responsibilities really are to support TradFi organizations, so banks, money service businesses, the likes, CeFi organizations, so crypto native businesses and centralized exchanges, and also DeFi organizations and some of the brands now looking to enter the Web3 space. And I support them in really, helping them understand their regulatory and compliance obligations from a practical standpoint, given the current landscape. And if you haven't heard of Chainanalysis, we provide data solutions to a lot of the industry, both public and private sector. Thank you.
Thank you. So, as we heard before, there are different legal structures available in different jurisdictions, and also there might be different obligations and responsibilities and so on, depending how we will operate. But maybe Anna, could you explain how DAOs are treated by the law and what are other types of legal organizations which might do the same business or activities?
I would like to start with, let's say, the general meaning of DAO is a common understanding. We do not have the official legal term for the DAOs right now at the moment in the European Union and in the Estonian regulation. So it is important to mention that there is a lot of unclarity for now related to the regulation of the DAOs. However, we still have different types of the legal structures potentially possible for the DAOs. And of course, we have different jurisdictions who already tried to regulate the DAOs, such as Switzerland, Liechtenstein. In Wyoming state, we already have the DAO regulation. Also, for example, Maltese authorities introduced the proposal of the DAO regulation. And according to my knowledge, in the end of 2022, UK authorities and lawmakers introduced the proposal of the regulation. However, we are still in the age when legal advisors are trying to fit DAO project to the local regulation, and depending on the jurisdiction where DAO will be registered, it can be different type of the enterprise or different type of the organization. In general, we can say that we have, let's say, 3 types of potential structures of the DAOs. The first one is let's say pure DAO, when we have the DAO without any governing body, and we do not have off-chain legal entity for this. The next type is when the DAO is actually owned by the legal entity, which is off-chain, and the members of the DAO are a part of this legal entity. And the third option is like combination of first and the second is the situation when we have the legal entity off-chain, then we have the DAO, and the DAO members are not a part of this legal entity, so they are still making the decisions in the scope of DAO, or in the scope of pure DAO. So it's really depending on the jurisdiction, and there are several legal structures that might be considered. The previous speakers also talked about it can be a fund, it can be a partnership, it can be a private limited liability company, even public limited liability company. It's really depending on the aim and nature of the DAO project, why it was created. Thank you.
Thank you. So Toomas, let's take an example that, for example, if somebody will approach you that I have very good idea to provide some very innovative and new financial product, and I have few friends and also some potential investors who could support this project. And you as an attorney, what do you suggest, where to start, what to do?
Yeah, as we're working with, I think, more than 10 DAOs, so it's quite typical situation for us. But I think the first question will be for us that how big is your community? Because if you come to us and say, hey, I'm an entrepreneur, I would like to create a DAO, and the main idea to avoid being registered as a financial service, then we say it's not gonna happen, because DAO means there's some community who is taking the governance, who is running and taking the lead on that. Otherwise, if you just try to call yourself a DAO, but actually it's still operating as any business or entrepreneur, it doesn't look good. If it's a social DAO, then it's fine, you can do that. But if it's on a regulated market, financial services, then we say usually no, we can make it. So it's much better if you come to us and you have strong community already in place. And then you say, hey, we would like now to operate as a DAO. There is a strong community. We know what we do. We have this, we want to launch some token to provide for our members some new possibilities, how to finance products, how to involve the community. And then it looks much better. So, because if no community, no DAO.
Okay, thank you. The next question is to Mari-Liis. What is and will be the role of Financial Supervision Authority? And again, if somebody will approach the FSA, when and how and they should do it or maybe not do it? Thank
you. Maybe if I can add to Anna and Toomas were previously saying, then I would point out that the most important thing here from the regulator's viewpoint is to actually do what you say you're doing. So if you say you are building a fully decentralized autonomous organization, as the name says, then do exactly that. Build it in a way that there can be, no questions whether you or anyone else maintains some form of control over the system. A DAO should basically be built so that when you launch it to the public, it will have a life of its own. There should be no way for you to guide how it will, evolve from that point onward. And if this is true, then financial regulations will likely not apply, and actually cannot apply, since if you approach this very practically, there will likely be no legal or natural person that the regulator can point out as the one in charge of the protocol. On the other hand, if you're building something where you have some, control of the system in the future, then just do not call it a DAO, and do not try to pretend that it is decentralized. Build it as the business it is, and follow the rules that apply to it.
Thank you. Question to Amardeep. What role does Chainanalysis play in helping regulators and other stakeholders to identify and mitigate risks related to blockchain, including money laundering, terrorist financing, and fraud?
Thanks, Viljar. So like I alluded to in my introduction, we provide a suite of compliance and investigative solutions that allow regulators, law enforcement, government agency, CFI, DeFi, TradFi, and the ecosystem, as well as brands looking to enter the Web3 space. And I guess some of our solutions allow you to perform counterparty due diligence, for example, by allowing you to analyze an organization's on-chain footprint and activity. Another solution would allow you to perform real-time monitoring of incoming and outgoing transactions in and out of your organization. And then also other tools will allow you to do a deep dive investigation into on-chain transactions that allow you to unpick and visualize complex transactions. So I'm not going to bore you today with the details of how we create those attributions, but we do this through kind of very highly complex analytics and heuristics to identify and attribute real-world entities to the clusters of wallet addresses that we've identified. So another part, that I think is really important here is looking at education, and I think that education is something that's required across the board throughout the crypto ecosystem, and it's something that obviously has been brought up a number of times today. So we provide in-depth training and certifications that allow you to access also industry experts who can deep dive into specialized topics to pretty much support you on your journey. And I think that's quite important as well, because creating a DAO or a bank looking to bring on crypto services is not an on-off switch. And I think we discussed that in the previous panels as well. There's a lot of time and effort that goes into it. There's a lot of mitigation and analysis of current risks that need to be observed, and also understanding your regulatory and compliance obligations.
Okay, thank you. Yes, thank you. So as our topic is also related to MiCA, and we need to talk about that also. And as Anna is experienced on this topic, can you please elaborate and then explain how this MiCA will reshape our existing world related to DAOs, and also what could be the challenges for DAOs when MiCA is implemented?
Yeah, thank you for this question. I would like to clarify here that MiCA is a fundamental legal framework what we expect to have soon. I know that a lot of lawyers hate MiCA because it's changing all the time, and there is already for 4 years argumentations regarding when it will be enforced, and we're still waiting for this. The good news are that MiCA voting should be in April 2023, and after 12 months when it's published, it should come in force. So in 2024, we finally should have the MiCA regulation in place. The MiCA will regulate fundamentally the markets of the virtual assets and virtual asset service providers, and also the process of issuing of the virtual assets or crypto assets. And maybe I would like to point, let's say, 5 main changes that MiCA will give to us. The first one, and maybe the most important, is that according to MiCA, when it will be enforced for the virtual asset service providers, when you receive the license from one country, you will not gonna need anymore to obtain for the license in another country. So it will be similar to the traditional financial world and passporting opportunity. Passporting is meaning that you have the right to provide the cross-border services in other European Union countries, and it will help a lot market players, because what we have for now, for example, if you have a registered entity who provides the virtual asset service providers, let's say in Estonia, and you would like to target and provide your services in Germany, for example, where is also the local regulation, and you want to officially target your audience in Germany to the German citizens, you will get the notice from local regulator BaFin, who will say that, oh, guys, it's very nice that you have the license from Estonia, but it's not enough. Please go and apply for the license in Germany as well. And it's very hard for the market players to comply with this. So the very first thing, as I said, so this passporting possibility and this possibility to be regulated only in one member state. The next is that we will have the clarification regarding the legal terms and types of the virtual assets. The third is that we will have the register of the market players. It's very important from the consumer perspective. So it will be possible to check if the company is regulated, which kind of services they can provide, if they are compliant, in which jurisdiction they can provide the services. So it will help a lot to bring the transparency to this industry. The fourth is, of course, related to the supervision. It's more for the government authorities. So the government authorities will be able to change the information about the supervisions, and supervisions requirements will be similar. And the fifth is, of course, the transparency with the issuing of the virtual assets, because right now we have absolute house related to this. I can confirm this 100%. Several member states have different approaches, different regulation. In some countries, you need to be regulated and get the license to issue the token. In other countries, you don't need anything. So it's absolutely unclear situation within the European Union. So MiCA will solve those main 5 problems. And if we are talking about MiCA and DAOs, then we need to understand that in the draft of the MiCA, one of the versions of the MiCA, because there was a lot of versions, there was Article 3, according to which DAO was in the scope of MiCA, but this Article 3 is out right now. So right now, officially DAO, like in general meaning, is out of the scope of the MiCA, but there are some exemptions that we need to take into account if the DAO is providing the services that might be considered as, for example, the virtual assets issuer or virtual asset service provider, then they will be regulated. And it is very important to mention that in the MiCA regulation, there is written very clearly that this should be a legal entity registered in the European Union. And this is the biggest challenge that I see here. Yeah, thank you.
Thank you. Mari-Liis, what do you think? What kind of challenges and also benefits MiCA will bring to a financial supervision authority?
Yeah, when we're talking about DAOs, I think the most difficult issue surrounding MiCA is, again, decentralization. If you look at the wording for MiCA, it says that it covers activities performed, provided, or controlled by some natural or legal persons, even if parts of those activities are offered in a decentralized way. But it also says that MiCA does not apply when those activities are offered in a fully decentralized way. So just to emphasize, generally MiCA applies to all crypto related activities unless those activities are performed in a fully decentralized manner, i.e. there is no activities or intermediary involved in those activities. And that is obviously where it gets complicated, because it is sometimes not very easy to draw the line between fully decentralized and intermediated. And the text we have publicly for MiCA also does not define what is fully decentralized. So this is something that will obviously have to be clarified through so-called level 3 work and guidelines. And for that, we will have to think about the timeline we have for MiCA. And as Anna said, the vote will be probably in April 2023, and then it will be published. However, the deadline for completing level 3 work is 18 months from publication. So we may have to wait until end of 2024 to really have a clear understanding of which business models exactly will fall under the scope of MiCA in terms of decentralization and which will not. And in terms of benefits, I think MiCA is still very, helpful because at least it gives some sort of bespoke tool set for regulators to use when dealing with virtual assets. Here, entrepreneurs and supervisors are actually, I would say, in quite a similar position, since trying to understand where virtual assets fit under current so-called DRAD fee regulation. And I'm not saying MiCA clears everything out, but I do think it will take us much closer to having a setup fitting for virtual assets.
Okay, thank you. Toomas, as you have advising a lot of DAOs, what kind of main legal problems have come up when you are facing advising them?
Actually, these are like a very day-to-day, these daily business issues. Like, for example, bank account. How you can imagine that your DAO will apply for a bank account? It's not doable. So this shifting from the crypto or the virtual currencies into the fiat, so it's almost non-doable. So that's the first issue. Sometimes we have seen the questions that some members of the DAO for contributing, they're saying that actually I need an employment contract because I have to apply for my resident permit or some visa. Then you say, okay, how the DAO can sign any working agreement, or it's not impossible in legal terms. So it is like these daily issues, but of course, as like a legal, these like a more complex issues that are about that. Exactly that. Are you truly a DeFi, or you actually pretending to be a DeFi? This is usually that's something you need to be very closely to see that how decisions are made, how big is the community, how the community is, how active these are. And but if you overcome that and we are actually convinced that it's truly a DeFi, it's a protocol-based automated decision making included, then we have this question that, okay, bank account, who signs the contract, who hires the software houses, for example. That has also been an issue that the DAOs are pretty good the clients for software houses, because they once they are financed, they need to purchase a lot of the services. And it's not always that the DAO is able to maintain and provide us as a community and open source all the software. So we're seeing that software houses they are providing services. Now the question, okay, where's the VAT number? Because otherwise it's cross-border in EU. And how we have actually targeted this question, said, okay, we need some link between the DAO and the real world. And we have been used NGOs. So it's easy to structure in Estonia. It's kind of like a foundation, but it's NGO form, M2 in Estonia. And the reason is that, so the NGO, it's also kind of this idea is that it supports non-commercial projects. It cannot share any profit. You have members. It's easy to shift the members if you need to add new one. So that's the link between the DAO and the real world, at least now, have been the NGO. So the NGOs are also able to apply for a bank account, not from Estonia, obviously, but there are solutions. So say hello to our Lithuanian friends. There is a lot of, actually last week in Paris Blockchain Week, I met like 4 or 5 Lithuanian EMIs for providing very happily bank accounts and IBAN accounts for the crypto companies. So these NGOs are usually structured in a way that they do not make any decisions on as financial service. They cannot influence that, but they provide kind of link that they sign agreements, they have VAT numbers, they can pay invoices. Of course, the question is how the NGO is financed. There is other issue, but there is also options that you can provide kind of this membership fees and etc. Or you can provide services even. So that looks like the NGO is like the, at least for ours, in our practice, the best solution to be like this kind of the sidekick for this DAOs.
Thank you. Next question goes to Amardeep. As there are also many DeFi organizations developing their products and providing services, how do Chainanalysis supervises the transactions and business activities of DeFis?
Thanks, Viljar. So I guess the role that we play from a macro perspective is to make crypto or virtual assets safe and compliant to interact with. And that's kind of the company vision that we have here. You know, and that allows us to kind of allow for innovation and the ecosystem to thrive. So I guess, you know, we have a heavy burden on our shoulders when it comes to regulatory compliance solutions. But what we tend to do is, as the industry matures and there's new challenges presented, we look to provide kind of solutions and support the ecosystem. So, you know, for example, before I get into DeFi, you know, we had the NFT boom of 2021, for example. So, you know, we developed a solution called Storyline, which allowed users to clearly unpick highly complex NFT transactions, which were really difficult to understand. They're not as easy to understand as sending a Bitcoin from A to B. But when it comes to DAOs and obviously DeFi or financial DAOs, you know, we've seen incredible growth over the past few years. And as the industry kind of shifted into DeFi, we too were presented with those challenges. So, you know, some of those challenges were in supporting CeFi organizations or centralized exchanges looking to provide liquidity to DeFi liquidity pools. Or they wanted to interact with DeFi but needed some sort of form of AML tools. And also some organizations wanted to conduct kind of risk assessments of liquidity pools for traders. And also there was other kind of you know, centralized exchanges or structures that were using DeFi backends. And I guess these are all the challenges that we were presented with. So, you know, we developed a solution that allowed analysts the ability to really risk profile DeFi platforms to monitor and assess counterparty risk, for example. So that allows you to get a bird's eye view of what's happening, you know, within that liquidity pool, for example, and allows you to gather the intelligence, you know, to become, you know, to really solve the issues with any concerns you have with your business's risk appetite. And I think the more recent, or more recently, we've seen actually dApps looking, or decentralized apps looking to implement compliance to allow screening before allowing, say, a user to connect to their Web3 site or to their DAO. So, for example, performing a sanction screen on a wallet before allowing it to connect to your smart contract on your website. And I think as the ecosystem matures, these are the kind of challenges that we will continue to solve to allow people to interact with the ecosystem in a safe and compliant way.
Thank you. Next question goes to Toomas. What kind of what investors need to take into account when investing into DAOs, and have you had already some disputes between organizations and investors who have invested and are not happy with the investment?
I think these are not now investors. I think who are not happy now are these consumers who has been part of these scams. They have to be truly, there are scams, a lot of scams has been, will be also in future. I think most of these disputes which we have on our table are related to that. It's actually, if you look inside, it's a pure scam. It's sometimes they even call them DAOs or whatever. It's like a good for marketing. So in that case, there's nothing much to do because there's no dispute between like this based on some contracts or terms conditions. It's usually we just lost our money. But for investors, it's a good question because they're asking again that, okay, I'm ready to invest. There's a DAO. What is the investment vehicle? There is no equity. So they say always, okay. And then we say that for investors to say, if you're ready to invest and in a DAO, it means that you will be, you're receiving the tokens, no equity, no shares agreement, no any protection as an investor for you. So it's pretty high risk for you, because you only receive like maybe just a SAFT agreement or something like that, which doesn't give you any rights as investor. So from the perspective of the investor's risk is pretty high, because if something goes wrong, you cannot protect yourselves. Usually the DAOs are designed in that way, because who are you going to sue? You cannot sue the DAO because it's community. You can sue on some legal entity which is in the middle, but there's always a question that, what's the contract? But the investors are taking the risk. I think for funds, it's more complicated, because funds investment policy doesn't allow you to take such high risk. So usually you see who is investing now in the DAOs are individual investors or these family investment houses. Or the clubs, not like a VCs. I think the investment policy even doesn't allow to do that. We have seen that now there are more and more funds coming on market who are also able to do that, but usually they don't take very high stakes, and and we always say that that's your risk, and you may lose everything because you never know what is the value. Are there going to be any secondary market? Because usually they're playing on secondary market. That's the only way how you can multiply investment. So it's a pretty high risk, but if something goes wrong, according to the contracts, which are now designed and provided by DAOs, don't give much rights for the investors. So that's the idea of DAO also, that you don't take liability. Otherwise, you cannot handle that in the future. It has to be like you need to trust the DAO and community to be investor there. It doesn't help any paper there.
Okay, thanks. Anna, when providing services, and usually all these DAOs operate in different jurisdictions. So what the DAOs need to take into account to avoid maybe legal issues in different countries, because the local laws, as far as the MiCA is not enforced, might be maybe even totally different?
Well, it's a very hard question to answer because there is not a lot of clarity, and this is a question maybe more for the lawmakers. We as lawyers, as advisors, are waiting for those answers. But my personal opinion is that if we are talking about the DAO projects, most of them are like cross-border. Members are in different states, and they are created maybe for the proposal, for the aim to provide some kind of products or services only in different countries. So important is to think about the protection of the members in advance, as Toomas mentioned, because what we see in practice that let's say founders or idea makers are thinking and focusing on creation of the DAOs, and they do not have the long-term strategy, how they will protect the members, how they will address the challenges with governance. So better is to think about this in advance. And on the previous panel, there was a discussion about the suitable jurisdiction. My answer will be the same, smooth and wave. There are no suggestions go to UK or go to Switzerland or go to Estonia. It's really depending on the type of the DAO, on the legal structure, on the aim, where are your potential investors, members, which kind of product are you creating? For example, would you have a plan to issue the token, for example? Where will be your potential clients and partners? It's all important, and it should be taken into consideration while making the decisions about the suitable jurisdiction to choose. And the second point that I would like to pay attention, that there is like absolutely wrong understanding about the DAO regulation in general. There is, we see this in practice as well, that founders and establishers are having an idea of making a DAO, and then they are thinking, of, okay, I will be absolutely independent, I will be not regulated, the law will be not applicable to me, and then I can create interesting projects. This is not right. It's absolutely wrong understanding. Actually, the law will be applicable depending on the legal structure and jurisdiction of the DAO, the Commercial Act, if it is a non-profitable organization, a Non-Profitable Organization Act, IML Act, maybe Securities Act, maybe MiCA when the MiCA will be in force, into intellectual property regulation, etc., etc. So making a DAO is not the easy tool helping to avoid the taxation, regulation, and compliance. This is my message that I would like to share, and maybe this is the most common trouble that we see right now on the market, that there is this wrong understanding. Thank you.
Thank you. Amardeep, if possible, can you explain maybe and bring some examples when you have cooperated with government authorities to fight against fraud and even discover some illegal activities, and what have been the key factors of this success when you have identified the fraud?
Thanks, Viljar. Yeah, so I guess we do work on a large proportion of kind of global crypto-related investigations, some of which I can't obviously delve into, but some are actually public. So I think a good example would be the Badger DAO hack. So if you're not familiar with that, I can provide a bit of background. So in terms of Badger DAO, again, a DeFi or financial based DAO who was looking to bring financial instruments to users without any intermediaries. The Badger DAO allowed people that held Bitcoin the ability to access EVM or Ethereum virtual machine based DeFi protocol using wrapped Bitcoin as a medium. So they allowed access to DeFi protocols from people holding Bitcoin. And in short, this was a Web 2 vulnerability that was found, which allowed hackers to gain access to API keys, allowing them to alter the smart contracts. So it wasn't actually, which was very interesting, wasn't a DAO or crypto specific related security risk, but more of a conventional cybersecurity exploit. But it did see in excess of 120 million of user funds siphoned out of the DAO. So again, we worked very closely with law enforcement, and we were able to analyze the historical footprints of the illicit actors together and share some intelligence. And I think that's something that's really important. So we identified that funds used to alter the smart contracts had directly or had direct exposure to other scams. And so, that allowed us to obviously gather more intelligence and understand that, we are more than likely dealing with an organized crime group rather than, either an insider job or just some sort of amateur illicit actors trying to commit fraud. So really, I think, in terms of the end result and maybe something that contributed to the success, I think definitely having some form of either guardian contracts within your protocol, any compliance risk related contracts to stop or maybe highlight when there is a significant amount or proportion of funds leaving your protocol. Again, obviously, speed is going to be something that definitely is, always of interest, and make sure that you can put a stop to the funds being removed. Some sort of form of ongoing monitoring of your pool as well obviously allows you to be alerted. When there is, I guess, a loss of funds. Things that are typical, such as good treasury management posture, multi-factor authentication. I think that's something, from a cybersecurity team perspective. But I think another important piece of the puzzle really is insurance and crypto incident response. So I guess that's something that all contributes to these types of investigations. I think putting security, insurance, crypto incident response and cyber security in the midst of a DAO, I think that's an interesting and maybe a conversation for another day.
Thank you. Toomas, what do you think if DAOs will open up new investment opportunities or bring us more fraud cases?
I hope no more fraud cases, at least on that scale that we used to have. I believe it's a great technology. It's a great example of Web3 also. But unfortunately, I have to say for all the fans of the DAOs that things not going easy. MiCA is there. Okay, there is nothing specifically about DAOs. Will be guidelines probably. But if you think about things like travel rule, which is also introduced by the MiCA, we already have that in Estonia. It's quite problematic already now to implement. So AML and all these ideas of that you need to identify the source of the financing. So it's I think the DAOs has to be quite adaptive and implement the same procedures as we have now in regulated financial services, like AML rules, because otherwise you can imagine off-ramp. Who's going to do the off-ramp if you have no trace of this and all these resources that you have? So I think the DAOs have to be one day implement as much as possible the same tools as now we have on regulated market. Otherwise, you cannot scale up. You're just going to stay in one circle and just high risks evolved. So I think the DAOs will be one day something similar as they have now in financial services, but it's fully into technical protocols, probably.
Okay, thank you. So as we can see, there are a lot of going on and there will be a lot of interesting developments, hopefully good ones only. And I think as there are also unclarity and things we do not know yet, so I believe that we need to keep open the discussion between the market participants, all kind of stakeholders, including also policymakers and financial supervision authorities. So I really think that very interesting times are, we will see soon. Thank you.
Thank you.
Thank you, panel, and thank you, online speakers as well, joining us. And and next we have now we can move. But thank you so much for coming on stage.